Okay, the recording has started.
Can you let everybody in from the lobby?
Oh, sorry.
Yes. So I'm gonna have to take off maybe a couple minutes early.
Good afternoon, everyone who's joining us. If you could please mute your lines, we won't get feedback that way.
Okay, is everybody's in from the lobby?
They're still working on it, but yeah, let's go
Yes,
forward.
they're in.
Okay, so thank you everyone for being here for this emergency meeting. Just so everyone knows, this is a public meeting, so it is being recorded and live and is a public document. So we are here to discuss the Blue Cross Blue Shield issue with them not reimbursing for physiotherapy codes. We're all fitting this in to our lunches today, I'm sure. So we do want to open it up for discussion, but I would ask that you would keep your comments to just 2 or 3 minutes so that we get through it.
Movement over the top of that instead of like.
Please mute yourself if you're on the call.
And so that we can get on with our days. So I'm trying to figure, I'm on my phone now. So if someone else can see who has a hand raised first and call on them.
Yeah, I'm not seeing any hand raised yet. And I know Vern Sabo was gonna try to attend and have a statement, but I'm not sure if he's on.
I think
Yeah,
Vern's
I'm
on.
on. Can you hear me?
Oh.
Do you want me to make a comment?
There we go, Vern. Thank you. Yeah, go ahead.
Well, first of all, I don't believe that Regions has a leg to stand on, and I think this is going to go away. It may be that there's just an individuals who took it upon themselves to create this policy without really knowing rule or statute. We have a rule, OAR 836-053-0012, subsection 8, that specifically states, and the OCA got this in 2017, it was updated in 2023, that states specifically, in the administration of essential health benefits and the EHB-based benchmark health benefit plan, an insurer may not exclude services provided by a doctor of chiropractic medicine if the services are otherwise covered under the plan and the doctor of chiropractic medicine is acting within the scope of the provider's license. Now, it's important to note that physical medicine and rehabilitative services, the 97 codes, are included in the Oregon Essential Health Benefits Plan under the category of rehabilitative and habitative services and devices. This is a federal requirement. And so they're in violation of rule if they continue and statute. And the statute specifically that we got through the non-discrimination language, specifically section 2706 from the Accountable Care Act, was first inserted into Oregon law, the first state in the nation, in 2015 with House Bill 2468, which applied only to individual and small group plans. And specifically, the language is an insurer may not discriminate with respect to participation. That means that they must allow some of us into the plan, under the plan, benefit, or coverage. Now, coverage is the piece we're talking about. If it's a covered health benefit, essential health benefits within our scope of license to provide under the plan, they cannot discriminate against us. Now, that's an Oregon law. The current governor is a champion of that, and that language is included in the bill that just passed that applies to large group plans. So the only avenue that the OCA sees that Regions might have is that their plan or plans, and I'm not privy to if there's more than one plan from Blue Cross Blue Shield that affects us, is if it is what is known as a grandfathered plan. Now, if it's a grandfathered plan, it has to have existed before March 23, 2010, and there cannot have been any substantial changes in the plan as per increased costs, raising contribution rates, or eliminating benefits. So when we had a meeting with the insurance commissioner a few years ago relative to this, and this is about Andrew Stoffy, he's no longer the commissioner. I specifically had Tom Daly, chief legal counsel from the ACA, on the line. And I distinctly remember staff stating that they couldn't hardly think of any remaining grandfathered plans. So it's more probable than not, sound like I'm in court now, more probable than not that the Regents plan in question is not a grandfathered plan. So I think this is all going to go away. It's just a matter of someone yinging when they should have yanged, because I don't see anywhere in statute or Oregon rule that they have a leg to stand on.
Michelle, if I could ask Verna a question.
Sure.
Verna, you said that you spoke with the insurance commissioner a few years ago. Have you or OCA particularly reached out to Division of Financial Regulation or DCBS and the insurance commissioner about this issue yet?
I haven't gotten to the commissioner, but I've been corresponding with a Brooke Hall. I haven't gotten a response back. She did answer the question. They're currently writing rules. They had a meeting in August. They had another one in September for Senate Bill 822, and she confirmed that the rulemaking has nothing to do with the Essential Health Benefits Plan. She did not answer my question of what are the current, if any, grandfathered plans where the non-discrimination provisions or the Accountable Care Act would not apply. She has not gotten back to me on that. But and this was November 10th that I corresponded last with her because that was one of the concerns, that they were rewriting rule. But of course, that can't conflict with statute. So we've been in contact. We haven't gotten word back regarding that particular question. There's been several complaints filed, and there's this response back that they're on it, they're looking into it, and so forth.
Okay, thanks.
Is there any other public comment? Dr. Rhodes, is that what I saw? Yeah, Dr. Rhodes.
Am I supposed to like raise my hand if I have a question?
It's helpful just so we can kind of keep order on a Zoom call.
Great.
I have Dr. Rhodes on my account real fast. We're just going to ask the question together.
So
Okay.
basically, the question is, until this gets resolved, what should we do, at our clinics? I've seen comments on various, Facebook groups saying, hey, just keep billing, keep treating. I mean, how do we handle disgruntled patients? The eviCore denials saying, hey, you can't do this. What's the best way for us providers to take care of our patients, but still remain, legal and following the guidelines? That's, I think, the main question. Like you said, Vern, it's going to get resolved, but between now and then, what should we do? And then also, why do you think Blue Cross is doing this?
Is that pointed at me, or what? Do you want me to address those?
Yeah, that'd be great. Thank you.
Or anyone.
Well, to your second question, I think there's just someone in policy that just didn't know what they were doing. I think it's that simple. And the first question, and this is only my opinion, this is not an official OCA stance. I don't think we've made one as far as what you should currently do, but my personal opinion is you continue, you don't want a disruption of care. You continue, the only person that's in violation of Oregon law and rule is Regents. You continue to treat as clinically indicated, make sure that your clinical notes validate and that treatment is necessary and they correlate with your diagnosis and your findings, and continue to treat and bill as usual.
We also have comments, questions in the chat. Brenda Koo asked, are the complaints filed by the OBCE and OCA or just individual chiropractors?
Well, currently it's individual chiropractors. We're formulating a response, but this coming Thursday, we'll really know where their position is because vouchers come in, and we'll have a better idea Friday morning. But right now, there's no official complaint filed by the association. There's just individuals who have filed complaints.
And
We
on
have
the
another question.
sorry, I'm going to jump in. On the OBCE side, the OBCE has not filed a complaint. So we have no jurisdiction here other than to determine scope of practice. So that's what this conversation is for us, for this regulatory body.
There's another question in the comments. Sierra Renner asked, has anyone actually gotten denials yet besides the Evercore ones?
According to the comments on Facebook, people have gotten denials when they've billed. So, and there was a comment on Facebook from somebody who had their patient contacted and said that patients were running out of benefits on the physical therapy side because they were being used by the chiropractor. So then when the patient needed care, they didn't have PT visits available, which, I mean, that's a Blue Cross policy issue, and they don't need to, you know, that's a whole nother issue, but I get on my soapbox about that one. But yeah, so I think at this point, letting Vern, Dr. Sabo, and the OCA kind of do what they do best, and then as a board, we can take a vote on whether or not we want to issue a statement about what is within our scope of practice. And that's kind of where we're at, I think.
Can I follow up on that? Per the website that was posted of Blue Cross Blue Shield statement, it actually says that within that statement that at least I read, instead of specifically saying it was going to deny us for these codes, it said Blue Cross Blue Shield is responsible for paying what is within our scope of practice. So I would assume it should be with the OBCE's responsibility to also file a complaint that they're not allowing us to be paid for treatment that is within our scope of practice. Not just the ACA and the individual chiropractors to form a formal complaint. That's my opinion.
Thank you. Appreciate that. Does anybody else have public comment before we make a motion?
Well, I'd like to make one is, has anyone that's on this received a specific rationale for the denials, such as these are not within your scope? Has there been a rationale that anyone has seen?
So part of what that response was that was on Facebook was issued that it was because of overutilization of 97140. And that's where this is how they are taking a step to basically curtail what they consider over abuse and overutilization of that code in chiropractic offices doing 4 units of massage that may or may not be necessary. And that's how they stepped in, and according to the report that I was told, secondhand, obviously, is that that's the reason Providence also switched over to their ASH contract for a lot of their contracts because of overutilization of rehab PT codes, but specifically 97140. And that's how Providence solved it. And Regents is trying this attempt to curtail use of that code in offices.
Well, they can't paint the whole profession with the same brush. They have to look at each individual office and address that issue. So that doesn't fly. But that is a critique I've heard.
I
and
agree,
that's-
but
Mhm.
that's what I was told. Yeah.
And that again is sort of thing that gives us a black eye, makes my job more difficult.
We have comments in the chat. Dr. Natasha Rudsager said only what they have told me via provider relations. Alicia Katz said, no, we've received notification that we can't provide therapies because we are a chiropractor instead of a PT. Dr. Natasha Rudsager said they gave those codes to LMTs instead. And Brenda Koo said that the question is what the denial code on EOBs. Dr. Natasha Rudsager posted a screenshot of something. Katana stated, I was told yesterday and have in writing that they updated the new policy to allow DCs to bill 97140 without a pre-authorization. And Dr. Natasha Rudsager, I'm trying to find the picture of their response. Katana said this was changed yesterday and I received it from BCBS escalation. You can see the screenshot in the chat if you like.
Thank you.
Seth?
One, I did hear the issue about the PT benefits being used by chiropractic offices, and that would exhaust it. And I think part of the issue that I noticed, and I think everyone else did years ago when EvaCore started, is that for some reason things like electric muscle stim and ultrasound suddenly got put under physical therapy instead of physiotherapy. So if you wanted to do stim on somebody, you had to get a physical therapy approval, even though maybe you weren't using rehabilitation, actual true like therapeutic activity, therapeutic exercises. So if that's their argument, I feel like they probably made this problem themselves by lumping physiotherapy under physical therapy and now telling us that we have to refer to a PT to get stim put on somebody. So that's the one issue I feel that weakens their argument, is that if that's true and we've been depleting PT numbers for patients, then they made that situation themselves by lumping physiotherapy under physical therapy for approvals with EvaCore.
Public comment, Dr. Natasha Rudsager posted a screenshot and said this is their researched response.
Does anyone want to summarize it? Because I cannot read it.
Yeah, it's really small.
Natasha, do you mind reading it out?
Yeah, let me get that up for you guys.
Or share screen.
Can you hear me?
Yep.
Yeah.
Okay, it says we've received some updates regarding the change of alternative care administrative manual. Alternative care indicates that the following is reimbursable. 98940 through 98943, 97140, 99211 through 213, our 201 to 203 codes, and possibly 204 with 205 and 215 with 214 to 215 with support submitted appeals upon a denial. X-rays are also included in orthotics of the feet L30XX, allowing orthotic management fitting 97760. Chiropractors may continue to refer for physical therapy and submit pre-authorizations requests for referred services, but physical therapy will no longer be reimbursed when billed by a chiropractor. This policy will not be applied retrospectively and only goes into effect starting November 1st. These types of changes are usually posted either in our newsletter or bulletin, which can be found on regents.com. I have attached a copy of the newsletter from August, which includes information regarding this change. The attached PDF is 2025 August regions from Idaho. So if you were in Oregon, you wouldn't be getting an Idaho newsletter.
So that was reading from an Idaho policy from Blue Cross?
Their bulletin newsletter is an Idaho policy, and it does not specify that they're not going to pay the 97 codes.
Yeah, the one I
Natasha,
have
are you
from-
saying it's only 97140 is allowable? None of the other 97 codes are allowable?
That they took it away and they gave it to, if you guys read the alternative manual script from regents.com, it actually will state that 97110, 97026, 97140, and 97124 was given to LMTs, and only 97140 is given to chiropractors. Everything else has been taken away.
I love that massage therapists are allowed to do rehab exercise therapy now for their patients. That's fantastic. That should be perfectly within their scope of practice.
Yeah, 97112 is also included, so neuromuscular rehab was included for LMTs.
To the hazy. Thank you.
I have a public comment from Katana. This is the excerpt from the email I received. You have mentioned CPT 97140 as well during our conversation, and I was able to locate some new information that became available yesterday, November 10, 2025, regarding this code. CPT 97140 shows as requiring a pre-authorization on our pre-authorization list and availability, but chiropractors are exempt from pre-authorization for this code, and there is a Alicia Katz posted a screenshot and stated a letter we received regarding a specific patient. We're in Oregon. There's also a public comment from Christina Goodwell. We also received notification via email from the BCBS Regents escalation team that 97140 was okay to bill, but 97530 was not. The policy change in the administrative manual has a footer that refers to Regents patients. We have called the home plan for BCBS of Texas, North Carolina, Anthem BCBS. All said no changes for reimbursement of rehab codes are in place. We are looking up all plans and alpha prefix. If they are not Regents, we are assuming we can bill as usual. I am supposed to hear from the provider escalations department on 11/14 if this change applies to all BCBS plans. And we have a hand up.
Yes. Sierra Renner.
Yeah. So essentially what I'm seeing is that we can still bill 97140 as they say it's within our scope of practice or whatever. They don't want us to bill 97530 or 97110. We bill 97012 and 97014 a lot, but I haven't seen that pop up at all. So I'm not sure if we're still going to get reimbursed for that or not.
Likely not.
Lovely. That's great.
Dr. Sabo.
Yeah, I'm looking at the Oregon Regents policy, alternative care policy, and I don't see anywhere where it says that we cannot bill for the 97 codes. I do see, as someone mentioned, under licensed massage therapists, they can, and it's spelled out, but I don't see anywhere. Or in Oregon, chiropractors cannot do the same. It just simply stipulates it has to be within our scope of practice.
I have a public comment from Brenda Koo. This comes back to our scope of practice in that it is illegal for insurance providers to limit which providers can be paid for services if within the scope of practice. And Alicia Katz has her hand up.
Yep, go ahead, Alicia.
Oh, well, I mean, if they deny this stuff, I mean, can we just charge cash? Like, hey, sorry, it's a non-covered service under your policy, so it's cash now. I mean, that's like worst case scenario. Does anybody see anything against that if it's a non-covered service?
So this is Lori, a public member, and you guys are saying a bunch of numbers, billing issues, stuff. What I'm hearing is you guys being doctors, are performing under your scope of chiropractic modalities and the insurance people are denying you reimbursement, right? So it's and I'm just trying to dumb it up for me and kind of get to the point. So you guys need from us confirmation that what you are billing is within your scope of practice. Is that's what you guys are asking for? Because I'm not, as a public member, I feel for you guys. I'm just like, it wouldn't be our complaint because we don't bill. We're not getting denials from insurance, but you guys are, and that doesn't seem like it's right. But you guys are the people that are getting the damages.
I would recommend it would be a benefit if the OBCE specifically referred to 97110, 97112, 97124, 97140. Those physical medicine codes are within our scope of license to provide. Would be a benefit. The 97 codes.
Are they coding the same throughout all insurance? So those are known within the field. And again, I'm the public member, so billing numbers 97. Yeah, I'm like, it's a bunch of zip codes to me, folks. So
yeah.
Yes, they're used across all, and it describes a procedure, so it's not exclusive to any one type of provider. And so that's basically what Blue Cross has done, is they've said, like, these are PT codes and you're using up PT benefits.
And like Vern said, within their actual published notification, it does not specifically say we cannot bill for those services. It says that we can bill for what's within our scope of practice, and yet we are being told by denials and prior authorization people such as Evacor that we're no longer allowed to bill for them.
I have a public comment, Katana. This was also in the email addressing what Christina was saying about all plans. During our call, you had asked if the change was only applicable to Regents members or all BCBS members. Initially, I had thought this update was only applicable to Regents members. However, I apologize, but I was mistaken, as it is applicable to all BCBS members. Aaron Montgomery said also 97530. Brenda Koo said in 97535. Christina Goodwill said, I received an email from the provider's escalation department that 97530 would definitely be denied. And we have a couple people with their hands up.
Yeah, Natasha.
Yeah, so I'm curious about one of the things that if you look in the alternative manual and the things that they've sent us about this update is that it's not, they want to make sure that we're doing under the right provider. Well, if they give these codes to LMTs, then the issue that I'm having with that is they're going to want us to bill under our LMTs and get them contracted, which is fine and dandy, except just like Pacific Source, they're no longer looking at the CA license and what encompassed in the scope of a CA license, which is an Oregon, according to Pacific Source, is an Oregon board problem to send them a response saying that you can't trump the CA license. And that's essentially what they're going to end up doing with this 97140. If we continue to bill it under ourselves because we have licensed CAs, they're going to tell us, no, it's actually an LMT and therefore you can't do that. And they're going to want us to bill and contract every single LMT, even though they come and go, you know, every 6 months.
Sierra?
My question is, with these changes and everything, we all signed contracts with Blue Cross Blue Shield saying that we agree that we will accept the allowable rates and not balance bill our patients if if Regents agrees that they will pay us the allowable rates for the services listed in the contract. How can they hold us to the contract that we signed if we didn't sign an addendum saying we were okay with this? Like, how can they hold us to not balance billing patients as in-network providers if they're not upholding their contract?
It's not a balance bill if they actually deny the service. You should be able to charge cash for the service.
Aaron Montgomery.
Yeah, Tony, I think that I think you're spot on because they say it's a non-covered service. The way I understand that, we can regrettably pass that cost along to the patient at that point, and then charge them our fee for rehabilitation services, physical medicine services. It's a downer because now essentially Regence's decision has penalized the patient heavily and like doubled, even tripled their cost of care for the same thing they were getting. So, but my understanding is yes, because it's a now they've stipulated it's a non-covered service that we would be okay to pass that cost along to the patient.
Public comment, Christina Goodwill, said she said only 97140 makes 0 sense as it is a physical medicine code, just like the other 97XXX codes. And then also, or how about the possibility that we can bill 97140, but they might deny it if in the same region or the adjacent region as a 98940/98941.
Alicia Katz, did you have further comment?
No, I think I must have double raised. I think the only
Okay.
thing that I'm trying to make sure, I guess I get clarified is maybe what the plan is from here. So as far as like, we're all processing it as, you know, however we're going to respond to it on Regence's side, but is the OBCE or the OCA going to take action and clarify like what the scope of service for chiropractors are to the insurance companies and kind of pursue that? Or is the OCA going to advocate for chiropractors in this? Or are we just viewing this as a non-covered service, billing to our patients? Even though technically in the insurance books, it is called a covered service. They're just not covering it if it's provided by chiropractors. So now that creates a little bit of confusion, I guess, on our side of like what we're able to do.
As far as the board goes, we would just need a vote to take action and charge CAS with issuing a letter. So
Yeah, I just want to clarify that action would be a letter issued, not a complaint, not a lawsuit, but a letter issued stating what's within the scope of practice of chiropractors and chiropractic assistants.
Like a good start.
I think that would be fantastic. That'd be a great start.
Brenda, did you have further comment?
Yeah, I'm just again questioning on the scope of practice, since many of us manage massage therapists or have them as our chiropractic assistant. It is quite confusing to me that those 97 codes have been given to licensed massage therapists as billable, because I am not sure exercise rehab therapy or neuromuscular reeducation is within their scope of practice, or they have any training on that. That is certainly not within what we train them for as a CA either.
That would be a massage board question. But I do know some of those codes, this is not an official board opinion, but some of those codes are about intent. So yeah, that would be a massage board question though.
Is that something that the OBCE can help also further clarify though for us of what is within their scope of practice versus us, since we're having to create this fight of the insurance companies having zero knowledge of what scope of practice is?
I mean, we can probably refer them to what the OAR, what the massage board or massage scope of practice. But that's probably it, right?
That would be the outskirts of what we could do. Mm-hmm. So if you're wanting clarification from the massage board, then you're going to need to do similar to what Dr. Rusgeiger did here, is request the massage therapy board to take it up. We're not able to touch that.
Okay.
No, this is Lori again. Dumb question. So do each insurance providers get to decide what and who can bill what numbers? So Blue Cross can decide, okay, LMTs can bill 97440 and then a different insurance company provider, MODA, can say, nope, LMTs can't do that, only CAs or what have you. Or is it across the board? Because it just sounds like certain insurance companies are making these decisions and impugning them on, or attempting to impugn them on you. And what we can do is just give a scope of practice type of letter, and if all the numbers are the same, the billing codes are all the same, can we include that in the letter? If I'm understanding.
Well, that's what I think is the issue, Lori, is that's what Vern said at the beginning, is it is per the Affordable Care Act, it is illegal for insurance companies to limit a scope of practice or to limit which providers can charge for a code.
Right.
That as long as it's within their scope of practice, all providers are allowed to charge for a code. What they choose to pay us can vary, but we are allowed to charge for it. That's what's illegal. And I think from a board perspective, just saying what our scope of practice is one thing, but we also need to say, in my opinion, the board should also complain. Besides the Affordable Care or the OCA should also be complaining or that this goes against legality.
I understand what you're saying. And I mean, I'm a practicing chiropractor as well, and this affects my office. But the board's job is to protect the public, and we're happy to issue something that says that these things are within our scope of practice. But as far as the rest of it goes, that's an association issue, and they'll need to take that up.
The only thing I can think of, again, Lori, there's a Lori, a public member, but the only thing I can think of is the impact I foresee this having on our public is that doctors are going to be forced to put the cost back on the actual patient, and then we would actually potentially see some sort of complaint or some kind of issue that would come before us.
That's an insurance complaint. You need to go to the insurance commissioner.
Okay. Okay.
So,
And I'm just trying to see how big what our letter can encompass and stay within our realm.
Yeah. And again, yeah,
I mean, put it out there, and then maybe people will complain if the cost gets put onto them.
Yeah.
I mean, that's who it's ultimately going to hurt if this does continue. So I do want to help the docs and help everybody. Like, I get it, I feel it, but it's also, we got to have an actual basis from our board perspective to help. Otherwise, it's meaningless.
Let me see. Natasha, did you have something to say?
You're muted. You're muted.
Sorry, fatty finger syndrome, apparently. If you guys do write a letter to Regents, just clarifying what chiropractors, the scope of practice for chiropractors and CAs, I would really implore you to write it to all the insurance companies. And a good example is I got audited by Pacific Source, and one of the things they took away, even though every single one of my LMTs, some of them are not actually LMTs, they're just CAs, they took away things just saying, oh, looks like massage, we better take it away. You should have provided it under a different rendering provider. And that doesn't, most of those were not licensed massage therapists. Those massage therapists chose not to renew their license and worked under my CA under years. So if you guys do write a clarifying letter, can we send it to every insurance company, not just Regents, as a reminder? Because it's just going to be another, Regents is the first one. Pacific Source is already locking down with only letting us use 3 units of 97140 because they say that it's out of our scope to do more. It's just a matter of time before everyone else falls in line too.
Yeah, that would be my recommendation, Michelle, as far as if a motion is being made, is to make it generic to insurance carriers and not specific insurers.
We have public comment. Alicia Katz, ChatGPT says this: despite the law, insurers like Regents craft their policies around medical necessity and internal benefit design, not explicitly around provider discrimination. Here's how they justify it internally. 1, benefit categorization loophole. They classify 97140 and 97110 as physical therapy benefits rather than chiropractic manipulative treatment adjunctive services. Then they say chiropractic benefits exclude physical therapy. In practice, they are relabeling scope appropriate codes as a different benefit category to sidestep 2706. Cost containment strategy 97140 to and 97110 are high-frequency, high-cost codes. By removing them from chiropractic coverage, they reduce utilization and payouts. Their actual aerial teams know this move cuts reimbursement without technically denying chiropractic participation. It's a semantic dodge. 3, weak enforcement of 2706. The law exists, but there's no strong federal enforcement mechanism. States were supposed to regulate it, but few have. Oregon DOI largely refers to the insurer's plan design unless you file a formal provider complaint alleging discrimination. 4, testing provider resistance. Insurers know most small clinics won't litigate or file coordinated complaints until the Chiropractic Association or AG's office challenges them. They get away with it. It seems spot on. We don't think that it is a mistake by some admin at BCBS, but it seems like an intentional scheme to not pay providers what we're within our scope of practice to provide to patients. Aaron Montgomery said Chad has nailed it, exactly what they are doing. Christina Goodwill, we already wrote a letter to the OR Insurance Commissioner last Monday and filed a complaint with the Region's Providers Relations Department. The more providers that do the same would potentially help. Dr. Natasha Brugsager, then they need to not have 98943 as a PT benefit. SM said, in service to the public, would a complaint from the OBCE not carry more weight than complaints from our individual offices? Yes, chiropractors suffer with this, but so does the public with regard to costs, and they're possibly opting out of necessary health care because of financial reasons.
Thank you, Heather. That was a lot. Unless there's anything really pressing, we're getting on in time. I am gonna, go ahead, Dr. Sabo.
Yeah, so I just got off the phone with Dr. Arnott, board member, who's very savvy in these areas, and he's gotten to the higher ups of Regents. They have not a clue what's going on. They don't have a provider relations department. They got rid of that a few years ago. So any questions, they send you to a provider, to a call center in the Philippines. So the other point he made, which is very important, is that there has to be, by law, there has to be proper notification of any contractual changes, which they have not done. And so again, I go back to the point where I think there's just one or two loose cannons within the agency that had a bee in their bonnet and just decided to inappropriately take this action. And I really believe that this is going to all go away. It's just a matter of time. But the OCA will stay diligent, but I don't see anywhere where Regents has any legs to stand on regarding this policy change.
Aaron.
Yeah, okay, so as Michelle said, we're getting on in time and I got to jump off here in a sec. Best recommendation right now, because I know there's other folks wondering here, is it sounds like continue care as normal, bill as normal. If we see denials roll in, let's sit around and wait and see what happens in terms of back reimbursement coming down the pipe later from Regents on this. Does that sound accurate as like the best recommendation at this point?
Yes.
If we issue a letter, which I think is a great idea, could we also direct it to all the chiropractors and they can include that in their billing? I don't know how it works, but with the scope of practice defined, can we add the billing codes of?
Yes. So what this letter could potentially look like would be a generic to the insurance carriers, incorporating the actual codes themselves that are within the scope of practice for both DCs and CAs. We'll put it on our website. We can send it out to the listserv, and that could be used as proof against denial. So to Dr. Montgomery's point, we're not going to answer that question for you, Dr. Montgomery, but we're just going to nod. And I'm sorry we can't, because we kind of just legally aren't able to. But to the question of what's in that letter, I think we can be as clear as we can.
I have another public comment. Nicole Bolero, should we still go through Evacor and get denials before continuing with our treatment plans?
Well, not speaking as a board member, but
I
as
would,
a,
I would,
yeah, I would
not answer that question.
It's
That'd
really
be a-
hard because a lot of the questions you folks are asking, again, this is Lori, the public member, but a lot of the questions you guys are asking, you guys should honestly go talk to an individual attorney or legal advisor, because a lot of the stuff we're not allowed to comment about just because of the board's scope.
Okay, so I'm going to make a motion that we, can't think of the wording, task Cass with drafting an email, or drafting a letter about what is it within scope for DCs and CAs that will be distributed to all insurance carriers and made available to licensees.
I'm going to clarify that motion actually, and not to have it distribute to the insurance companies, but that we will have available on our website and out to the listserv. So out to our licensees, but not out to the companies themselves.
Okay.
Michelle, can you restate that motion? Sorry.
I can, if you want me to, Michelle.
That would be great.
Yeah, so Michelle moved to task me with drafting a letter about what's in scope for chiropractics or chiropractors and chiropractic assistants. And we will distribute that, or we will post that letter on our website and distribute it to our licensee base.
Second.
Yeah, second by Lori. We have a motion and a second. Any further discussion?
And one question, is there going to be dispute about what these codes are and aren't? Again.
No, they're defined.
Okay, I was like, is it, okay,
There's
black
a
and
code
white?
that defines them, yes.
Okay. No
Okay.
further comments. Thank you.
If there are no further comments, then we will take a vote. Karen?
Aye.
I think Scott had to get off the call, right?
Yeah.
Corey,
Aye.
Mike,
Aye.
Lori,
Aye.
Micah,
Aye.
and an aye for myself. Motion carries.
Okay, so we will get that letter out as soon as we can. Everyone, thank you so much for attending and for your interest in this topic and for your immediacy. We really, really appreciate it and your input. Thanks, Vern.
I'm going to stop the recording 1 second.